Ask not what we all be can do for you. Ask what you can do for we all be.
For your information purposes, this proceeding will be broadcast on the internet. Starts at 5 minutes before the scheduled hearing time, which will be 1:25 p.m. So everything you say, everything you do is recorded and transmitted. That's mostly for the attorneys. Also, if you have any cell phones or electronic devices other than those already authorized by the court, please turn them off at this time. If they go off during the proceedings, you'll be asked to leave. Also, for the attorneys, this is no stenographer. Everything you say is recorded. When you speak to the court, please stand directly in front of the lectern, in front of the microphone, and do not move side to side because the microphone will not pick you up. We want to make sure we get everything on record. Thank you very much. All rise. The Honorable Supreme Court of Mississippi, Chief Justice Waller presiding. Oyez, oyez, oyez. All persons having business before the court are admonished to draw near and give their attention, for the court is now in session. God save the United States, Mississippi, and this honorable court.
Please be seated. Madam Clerk, would you sound the docket?
Yes, sir, Your Honor. Cause number 2012-EP-1340-SCT, Curtis Giovanni Flowers versus State of Mississippi.
What says the appellant? Now, let's see. You're Miss Sherry Lynn Johnson, is that correct? And you are making your appearance by filing of a pro hoc visa paper, is that correct? And you're with Cornell Law School. Are you a professor? I am. Okay, thank you. Welcome to Mississippi. And for the state? Very good, Ms. Madam Clerk, if you have other duties, you may be excused. Ms. Johnson, you may proceed.
May it please the court, I'm Sherry Johnson, and together with my co-counsel, Allison Steiner, I represent the appellant in this case, Curtis Flowers. This is a tragic case, a quadruple homicide, but this is also a case that is remarkable in three distinct legal ways, three ways that are interrelated. First of all, the number of trials. 6 is unmatched in capital litigation in the entire country. Second, the dearth of credible evidence implicating Curtis Flowers and excluding Doyle Simpson. And third, the state's insistence on cheating in a variety of ways. I am not going to address the sufficiency of the evidence in the argument. This is an unconventional sufficiency case. It's not that one element of the crime may not have been proved adequately. The state has many witnesses, 21 witnesses, and none of them produced credible, probative evidence that can be reconciled with each other. But that argument, which is set forth in detail in our brief, is one that requires fly-specking of each of the testimony, and I think our time here is not as well spent as this court focusing on those details later. Instead, what I would like to focus on is 3 of the ways in which the state cheated in this case, because it is this cheating, of course, that both necessitated so many trials and made the verdict in this case possible despite the weaknesses of the state's case.
Ms. Johnson, I hate to start this way, but cheating is a term that can have a legal sense, and I would prefer that you use a different characterization, a misstatement or something like that, but I'm not comfortable with that unless we've got some legal finding if that's what it was.
So I will certainly avoid the use of the word cheating, although I think in part the previous decisions of this court make clear that it's conscious misconduct, not just inadvertence.
Well, that may be so, and I think that's what my recollection is, but I don't think we use the word cheating.
No, Your Honor.
Thank you.
First, I'd like to address the state's misstatement of evidence in closing argument, then the unconstitutional procurement and introduction of an unreliable identification, and lastly, if there is time, the state's racial discrimination in jury selection. Well,
Ms. Johnson, just so I'll understand as we get into the arguments, were you present for trial? Were you a trial attorney?
I am not.
You got on the case at the appellate, just at this appellate level?
Yes, I am.
Have you been involved in previous Flowers cases?
No, I haven't.
Thank you.
Ms. Johnson, as you begin your presentation, would you answer one question for me that I think is relevant to what you're discussing, and that is the fact that this case has been previously reversed by this court, and that among the reasons for reversal are issues which are raised in the case today.
That is correct.
What sort of weight should the court give that?
Well, Your Honor, I think that is what makes it possible to conclude that these misstatements and other misconduct was not inadvertent. It is, of course, possible for a prosecutor, as it is possible for anyone, to make a mistake. But when warned about a particular mistake, and that mistake is then repeated in a slightly different form, then I think intransigence has to be inferred. And so I think that's not true of all of the errors that I'm talking about, but it is true of several of them. So if I might turn to the statement of the evidence in closing argument, the state's case, if viewed by a reasonable juror, had 4 different problems. First was coherence between the accounts of its various witnesses. Second was a sufficient motive for a man without a criminal record, a man not mentally ill, to have committed a quadruple homicide. Third, a way to exclude Doyle Simpson as a perpetrator. And fourth, an explanation for how a single man, not a marksman, no one with special training, could have shot 4 people at close range in the circumstances as they were found. Lacking the evidentiary answers to these 4 problems, the state lied about each one of them in closing argument, and Your Honor, so I do think lie is the correct statement, but if you're uncomfortable or would prefer that I say misstated the evidence, I'm happy to say that.
I suspect that they've got a response to what your characterization would be, and I think I would prefer to keep it in a respectful tone.
Your Honor,
Was there an objection during the closing to any of these statements?
there was not an objection to any of them, no. And if you'd like me to address now,
That's up to you.
then I'll save that for the end, because I'd like to talk first about how egregious they were, and then talk about why this court should address them in the absence of an objection. So the first issue is timing, which in this case actually translates into opportunity to commit the crime. The state's witnesses actually contradicted each other in numerous ways about timing, about what the defendant was wearing. None of them actually agree with each other, but most of those could be put aside as failed memories or somehow mistakes. But there was one really crucial discrepancy, and that discrepancy related to the opportunity Curtis Flowers had to commit a crime. Sam Jones, who discovered the bodies at the store, testified that he got a call from the store a little after 9, and that he went to the store then, arriving between 9:15 and 9:30. And indeed, he then added, it wasn't 9:30, so it was before 9:30. His testimony contains no other description of the timing of his actions.
Well, it's not exactly true. Wasn't he the one who, don't we know that he placed the 911 call?
He placed the call, but his testimony has no other.
I understand that, but he placed the 911 call. We know what time that was. That's not disputed. And didn't he say he was there about 15 minutes before he made that call?
Yes, that's true, but we don't know, so there could be a lot of possible explanations for this discrepancy. And I think one could be that he was mistaken about when he arrived, another could be that he was mistaken about when he made the call. There could be other people who were mistaken as well. But
I understand that, but I'm saying to say that his testimony is clear and not disputed is not exactly accurate, is it? I mean, even taking his testimony on those 2 events, when he said he arrived and how long he said he was there before the 911 call, there's a difference in that testimony, correct?
there's a difference in that testimony. There's only one account of what it is that I'm going to say was the misrepresentation, which is when he arrived at the store. And that is, of course, the critical question, whether the window was open. And the problem with that arriving at the store between 9:15 and 9:30, when the homicide had already occurred, was that both Porky Collins, who is outside the store and witnesses 2 people arguing, which the state argues is both Mr. Flowers and the perpetrator, and Clemmy Fleming, who claimed to see Flowers running away shortly after crime, claimed to have seen him after 10, or shortly after 10.
At what time does the evidence show that the 911 call was made?
I don't recall, Your Honor.
Maybe 10:20, wasn't
I don't recall, Your Honor. I'm happy to look it up.
Okay.
I don't know. So the problem here is that the perpetrator of a quadruple homicide doesn't hang around the crime scene for half an hour. Certainly not someone who's execution style by himself. So the problem had to be fixed, and the fix was to misrepresent the evidence. In closing argument, the prosecutor stated, Mr. Sam Jones came into the store slightly after 10 on the morning of the 16th and discovered the bodies. There is no evidence in the record for that statement. Jones did not testify, and no one else said anything about when he came into the store.
Excuse me, did he not say he was at the store about 15 minutes before the 911 call was placed?
Yes, Your Honor, he did say that.
Okay.
But he did not say, no one, I mean, he may have been gone, he may have done something else in between, he may have been in shock, standing there for a long, there are many possible explanations, and I'm not actually saying that the state might not have tried to offer these explanations to the jury. But what they did instead was to say, that's when he arrived. And in Flowers 2, this is a repeat in a slightly milder form of what happened in Flowers 2.
But couldn't the prosecution argue the inference that could be considered by the jury from the other witnesses' testimony that he arrived about 10?
Your Honor, if they had argued that, if they had said, the inference from the other jurors' testimony, of the other witnesses' testimony, was that he must have arrived at 10, despite the fact that he said, that would be no problem at all. That inference can be made, and that's, it might be true. I'm not actually disputing whether it's true or not, but it fixed a hole.
If it may be true, how's it a lie?
It's a lie to say that he arrived. There is no evidence here that he arrived. But all right,
But there's evidence that the call was at 10:20. There's evidence that he was there about 15 minutes. That's evidence.
Well, that's evidence. But if you assume that he knows what he's talking about when he says it was 15 minutes, then you might assume that he knows what he was talking about when he said it was not 9:30.
Well,
now,
the last jury, the one we're considering, that heard his testimony, did not even see this man. He's dead. Isn't that correct?
that's correct.
All that was read was his testimony from a prior trial.
That's correct. So what I wanted to say next is this is an improvement over what the state did in Flowers 2. And indeed, that's also true with respect to the question of stating about the statements they made about motive. In Flowers 2, the prosecutor stated that a witness had testified that Flowers was mad
But
because...
first tell me what he said in this trial. That's what we got to decide.
The investigators learned pretty quickly when they were asked who in the world could have had some reason, some motive, some anything to attack 4 people like this. Have you anybody that's had a beef with the store? Just one. And so that's minor. But a beef with the store, there is actually no evidence of a beef with the store. And it
Did
is true.
Simpson testify that he was upset about being fired?
He did not. There is no testimony by anyone that he was upset or mad or displeased, and indeed, he had no basis for being upset or mad or displeased. Mrs. Tardy treated him quite well under all of the circumstances. So, I mean, in fact, he had less basis for being upset with Mrs. Tardy than the jurors, the potential jurors who were sued by her. There's really, he's let go from a minimum wage job when that he failed to show up for several days after he made a large mistake.
Excuse me, what significance do you place on the fact that he didn't come back to work for a few days and didn't know whether or not he was fired? He had to call to find out.
Well, so I suppose this is rank speculation, but I can speculate. I can assume that he didn't come back because it didn't seem all that productive, since he was going to have to pay for the batteries that he lost, and then maybe thought about, well, maybe I do want this, and he called and asked. I think there is no testimony about that.
But the purpose of my question, and you say you can assume, you always have to assume when you talk about motive, you don't know what's in someone's mind. Motive, you have to assume from the facts. And the fact is that he didn't go back to work for several days, and during that period of time, he didn't know if he was fired or not. So how does that affect the argument concerning motive? In other words, he didn't just go to work one day and they said, you're fired. This incident happened, and then he stayed at home for right? Am I right? Maybe 3 days, 4
Yes.
days? And then he called to say, do I still have my job? Now, how does that affect the motive?
I don't think it says very much about motive at all. Of course, the state would be free to argue that although he never said he was angry, and no one ever heard him say he was angry, in fact, he must have been, because he made that call. They could argue that, but there is no evidence that he had a beef, and the investigators did not have evidence that he had a beef.
Why is that not a reasonable inference from the check being, his check being deducted, him being accused of misusing the batteries, and him being fired? Why is that not a reasonable inference that the motive is he was mad because all these things happened, in our opinion? What's wrong with that?
Well, if you want to argue that he must have been mad, you can argue that he must have been mad. To say he had a beef, there is no evidence that he had a beef. But maybe what I should do at this point is to say what I was going to say next, which is those two cases are both cases where the prosecutor toned down what it said to something that is at best ambiguous. Perhaps it was not intended to confuse the jury. Perhaps it was not an overstatement of evidence. But then we look at what else the prosecution said. And this makes it very clear that there is no mistake involved there, and there's certainly no mistake with respect to what is said about Porky Collins and his identification of Ray Simpson. There is no way to say that that is anything but untrue. The entire paragraph of that statement is describing that 2 lineups were shown to Porky. Okay, that's fine. Doyle Simpson's picture was in the first one. Okay, that's fine. Because later on they knew the gun came out of Doyle's car. Again, fine. And so they gave this thing to Porky first and said, this is the guy you saw in front of Tardy's in this group. Now, if he's going to make a miss of identification, ladies and gentlemen, that would have been the perfect time for him to pick out one of these guys and say, yeah, there he is right there. But you know what? Porky did not misidentify anybody. He said, the guy ain't in there. He never said, the guy ain't in there. What he said was that the photo of Simpson looked like the person he had seen. There's no way to transform looked like the person he'd seen, not a positive identification, but a resemblance, at the very least, into he said the guy ain't in there. And then the prosecutor goes on to say, he was offered a chance to mess up, the perfect chance. It didn't develop that way, but it's almost like a trick. You know, see if he is in there. No, he is not. That is not what happened. That is just not what happened. There is no way to read what happened in that account of either Porky or the police officer who was there as him saying, no, he isn't in there. No, the guy ain't there. None of that. That is not what happened. And so,
was that explored during direct examination or cross-examination of that
it was.
Officer? So the jury had heard what in fact was said.
Well, the jury heard it in a mild form. Of course, Porky Collins by this time is also dead, and so they hear the reading of his testimony. They don't have an opportunity to view him, so it may not have made as much of an impression. But certainly the testimony was read.
If the true testimony was before the jury in the trial, is that correct?
That is correct.
There was no objection made to that in closing statements. Is that correct?
Pardon me?
There was no objection made to that, was there?
There was no objection made.
And did the defense counsel argue on the other side in closing argument that that's a mischaracterization, this is what really happened?
No. They did argue about it, that it was an unreliable identification. And I want to say, the last thing that we list as a misstatement is the most open to a charitable interpretation. You know, I would say, so we could say the bodies were all in a pile, all in a group. I do think that characterization was false. Ms. Tardy's body was 15 to 20 feet away, and it does help in the obstacle that it does not appear that one person could, at close range, shoot 3 of the 4 people.
Were there photographs placed before the jury?
Yes, there were.
Sketches or
Photographs.
distance diagrams done in place before the jury?
Yes, there were.
So
So
they had the evidence to know that there were not 4 bodies in a pile.
That's true, Your Honor, but of course that is actually virtually always true with misstatements of evidence. The jury has heard the actual evidence. They are, of course, instructed to pay attention to the evidence and not to the arguments of counsel. And the problem, of course, is that a prosecutor is trusted. A prosecutor is a person who's trusted to tell the truth.
Why do you think that's so important, the placement of the bodies in terms of where they were and one being 10 or 15 feet away?
Well,
why did that hurt the defense so badly, in your opinion?
As I said, I think that's actually the mildest of the mischaracterizations, but I think the way in which it's harmful is, I'm not a gun expert, but I do think it's difficult to see how one person killed 4 people, 3 of them shot at close range, 1 of them at a distance. Now, it's possible, of course, to have a theory that there was someone else there besides Curtis Flowers. That's not the theory under which the state proceeded. So I think that is another obstacle, another little slight step beyond the facts to help. What is another weakness in the case? And so I think that that is less important, but it is cumulative in the sense that your job, of course, is when we're thinking about plain error, is to think both about whether the error is obvious and whether it is harmful. And I think while it would be difficult, I think the one error that's probably by itself sufficient is the misstatement saying he ain't there. But I think all of those taken together fill the holes, fill the weaknesses in the state's case. And for that reason, I think that looked at cumulatively, they merit this court's plain error review and they merit reversal.
And the pictures, there were 3 bodies that were at least arguably in a pile, is that correct?
Your Honor, I think a pile is not accurate. They were, one of them was about 5 feet from the others, not a pile, but relatively close. I think that's...
There were 3 that were relatively close and 1 that was 15 feet away.
Yes, that's correct.
Ma'am, our standard here in looking at such arguments is for this court to decide whether the natural and probable effect of the improper argument is to create unjust prejudice against the accused so as to result in a decision influenced by the prejudice so created. And so are you taking the position that these 4 errors that you have pointed out in these arguments were such to prejudice the outcome of this case?
Yes, Your Honor, because on all 4 points, all 4 weaknesses of the state's case, they gilded the lily by describing facts that were not in evidence. And so, as our sufficiency argument goes to some length to explain, there are many odd characteristics of this case. There are many weaknesses in this case, and that's why errors that go to the heart of the state of the weaknesses are errors that indeed do cause that kind of injustice.
Why is it too much for this court to expect that prosecutors trying a case like this would make contemporaneous objections so that a trial court might be able to deal with those issues at the time so that jurors can be instructed on issues that they claim to be error?
Your Honor, it's not too much for this court to expect. But, of course, this court's plain error doctrine does anticipate that sometimes trial counsel does not do that. It is also not too much for this court to expect that a prosecutor, having been warned once, would steer far away from anything that this court...
I'll assume that those defense attorneys had also read that case.
I would assume so.
In Flowers, too, and would have been prepared for such objections had they thought it really to be something that was prejudicing their case. Would you not? I mean, to say the prosecutor was warned, but everybody else in that courtroom had also read that case.
The prosecutor was warned that what he did violated due process. And I think that that is a different kind of warning than whether at some point something is slipped in that is a factual statement. But I see that I only have 2 minutes left, and I would really like to turn to identification, if that is all right. The state has cited Carruthers.
I want to ask you one question before. Had the prosecutor, if I understand your argument, had the prosecutor not said these 4 things, otherwise if he had not even spoken, just passed on closing, that there's insufficient evidence to convict.
The weight of the evidence is not sufficient to exclude Doyle
That's a
Simpson.
jury decision to weigh evidence, isn't it?
Yes, it is, but this court
We
does.
look at sufficiency of evidence in favor of the jury verdict, and so in the absence, is a jury argument, had that argument not been made, there'd be an entirely different result.
Your Honor,
Because
that's
there's
not,
insufficient evidence to support each of the charges against Mr. Flowers.
no, Your Honor, that's not my argument. I do think the evidence was insufficient because there's insufficient credible evidence to support the verdict. But I don't think I can know or anyone can know what a jury would have done in the absence of those errors.
But the jury determines credibility, not you or I or the trial judge. The jury decides credibility. Do you
The
agree?
jury decides credibility, but this court's standard includes an evaluation of the credible evidence. I didn't write that standard, that's what it says. And I think that that is designed for cases where there are extraordinary conflicts, such that the evidence is simply not credible. I think Odell Hallman is one such example. But I really would like to speak something about identification. The state has submitted a brief on Carruthers, and I want to point out that Carruthers is a completely different case, and indeed actually demonstrates why this case is sui generis, and really, you're not going to see another case like this again. Why? Because on the issue of impermissible suggestiveness, there is not only what there was in Carruthers, which is a different photo, a photo that is more noticeable. Certainly, looking at that photo, I defy anyone to say that that's not that the picture of Curtis Flowers is not the one to which your eye is drawn. But that might not be enough, and indeed, it might not even be enough to say that, oh, well, he's of a darker complexion than everyone else. And he has a receding hairline, which actually in the previous question about the identification of Doyle Simpson, he mentions a receding hairline. Those things are in the ballpark of what happens in every identification case. What does not happen...
Ms. Johnson, I notice you've been out of time for quite some time now, but I did have a couple of questions pertaining to Dr. Neuschat's affidavit. Are we going to have time?
No, we're going, this is a death penalty, we're going to take all the time we need.
So when you get to that point in your argument, I do have a couple of questions pertaining to the affidavit.
Your Honor, might I summarize the differences between brothers and then step down or answer another question?
No, we're going to hold it for questions, so please summarize that, and then we're going to open it for questions.
But I think what is unusual on the suggestiveness is that he's shown one lineup, tentatively identifies someone, says that looks like him, I'm not sure, and instead of going out to investigate that or doing another lineup, immediately he's shown another lineup. That is suggestive you got the wrong guy. But if that were not itself sufficiently suggestive, when he gives another tentative identification, it looks sort of like him, about Curtis Flowers, then the police officer says, do you know Curtis Flowers? That wasn't the same response he gave to the tentative identification of Doyle Simpson. No, that was, do you know Curtis Flowers? By that time, Curtis Flowers' name is in the community. Mr. Collins had said that he had acquaintance with that. So those are the suggestive features that are not present in other cases.
Wasn't Mr. Collins, and he the witness that said he saw two men
Did.
outside the store? And so, you think that's unusual that he would identify two different people out of those? Or point
Well,
two
he
different?
certainly gave no suggestion that in fact, no, that's not even possible because he said that he could only identify, he only saw one's face. So he's talking about the same person. But I think also the thing that's really the most distinctive from Carruthers and every other identification case is that when we look at the reliability factors, what the Biggers court says are the linchpin of admissibility, every single one of them weighs against admissibility. His opportunity to view was very different. This was not a victim of the crime who was close up, and he caught a glimpse at a distance while he was while he was driving. On the second pass, he didn't see the face. The degree of attention, also very different than a crime victim's attention. In fact, he said he didn't suspect a crime. The time lapse, 39 days, and this court in Christmas did say that 43 days weighed against reliability. The initial description was extraordinarily slim, a black man with a complexion that either was like that of Johnny Hargrove or was medium, according to whichever witness here. And his level of certainty, he made a tentative identification, he made another tentative identification, only when he's prompted does he say, yes, I'm sure. Then in Flowers 1, on the stand, when asked to identify Mr. Flowers, when he's sitting in the defendant's chair, he says, I'm not sure, he didn't have on glasses. Then he takes off the glasses and he still isn't sure. Now by Flowers 2, he says he's sure. So all of those indicia are different and mark the unreliability. And then the sort of final factor different than Carruthers is that the trial judge in this case made several mistakes, 5 different mistakes in recounting the evidence or the standard. And so the normal deference that would be given to the trial judge's finding is not appropriate.
Ms. Johnson, at this time, are there other questions the court has? Justice Chandler?
Do you have Dr. Newshutt's affidavit there with you, Ms.
I
Johnson?
do not have it in front of me, but I'm sure my co-counsel can come up with it.
Thank you.
Do you want her to get it?
I think probably, unless you have it committed to memory, you might want to have that come in front of you.
I would like, just for my benefit, I think the Batson issue is pretty important, and you haven't had a chance to address that. I would like for you to address the major points of your argument so that we may hear from the state and their rebuttal.
Thank you, Your Honor. I think the reason I put Batson last, despite the fact that I am convinced that racial discrimination occurred here, is because this is an unconventional Batson case. It's unconventional because any comparative juror analysis, which is what the court says in A.L.L. is the most persuasive, cannot really be accomplished here with conclusiveness. So it is true, there is no juror about whom the state did not give a facially neutral reason where there's a white juror that exactly matches. And that's the reason that I put it last. But I do not put it last because I don't think that racial discrimination occurred. I think that we have an unusual combination of evidence that should lead this court to conclude that racial discrimination once more has occurred. And when I say once more, I do think actually this is a prosecutor who, in this case, discriminated in a way that this court described as the most egregious violation of Batson it had seen. And I want to point out that that wasn't actually the only time that he violated Batson, because that was in Flowers 3. In Flowers 2, the trial judge found that he had discriminated and replaced one of the struck jurors, one of the jurors that the prosecutor struck, and put him back on the jury. So this is someone
Let's
who
talk
has...
about this case. I want to hear about the discrimination in this trial.
Well, Your Honor, the Supreme Court has said that the history is relevant, and it's found that relevant even when it's the office in a different case.
So you want us to look at what that office did years ago in the previous Flowers trial to find discrimination in this trial?
Not by itself, Your Honor. I would never claim that a prosecutor could not mend his or her ways. They certainly could. And but I do think that a prosecutor's willingness to engage in discrimination in 2 previous trials of the same case and not tell the truth about what he's doing is a relevant fact. It is not dispositive by itself, but it is a relevant fact. Then I think there is what I must admit is cute, the capital non-jury capital shuffle. I call that a shuffle only because the Supreme Court said in A.L.L. that the Texas procedure, which is a jury shuffle, perfectly legitimate procedure, can, used in a certain way, be another indicator of racial discrimination. And here what we have is an extremely unusual pattern. So we have proceeding capitally through 3 trials. Okay, that's normal. With a quadruple homicide, I think that's not surprising. Then we have a case in which the state moves to a non-capital prosecution. jury was hung. Then the state moves to a capital prosecution, and in that prosecution, which we would expect will produce fewer African American jurors because more African Americans statistically are opposed to the death penalty, we have 3 African American jurors. That also hangs. The state then proceeds capitally. And I will say, in neither of those 2 trials was there any allegation of discrimination. Both of them are
Now, your time is short, and I'm still waiting to hear what the discrimination was in this trial. That's what we're looking
All right, Your Honor, if you don't want me to cite the other things, I won't cite the other things. So I think
Only if they happened in this trial. No, I don't want to hear any more history. I want to know what happened in this trial that points to discrimination.
He accepted the first black juror without much questioning at all, despite the fact that that juror knew Archie Flowers. He struck then the five remaining black jurors, indeed all 5 black women jurors that were presented. He questioned them in an extraordinarily disparate way, a way that there is no explanation for, because although the state says, well, there's reasons he didn't ask as many questions, four of the jurors, white jurors, who said that they had relationships with defense witnesses, got only 1 question. So
Is this individual voir dire? Is this
Yes.
on death penalty individual
Yes, Your Honor.
voir dire with these jurors you're talking about?
Yes, and disparate questioning is another factor that the Miller-El court has said is relevant. And he mischaracterized the record with respect to at least 3 of the jurors. And I can go through each of those, but I think it isn't that he doesn't state a race-neutral reason, but the Supreme Court says jurors are not cookie cutters, reasons will not be identical, and I think when you get disparate questioning, you produce reasons that you might not be able to cite for someone else. And then when you exaggerate those reasons that you mischaracterize in the record, that also is an indicator of racial discrimination. And I think taken together, all of that meets the burden of proving that it is more likely than not that racial discrimination was at work here.
Would you identify for me the specific mischaracterizations that you were referencing?
Yes, Your Honor. So with respect to Carolyn Wright, what he says is she knows almost every defense witness. That's sort of half true. She actually knows more prosecution witnesses than she knows of defense witnesses. She also, the prosecution cites that she has a relationship with Sharita Baskins, Flowers' sister, but in fact there is no evidence in the record that she mentions any relationship with Sharita Baskins at all. And she also the prosecution also exaggerates the evidence of Wright's involvement with litigation in Tardy Furniture. They said she had to have her wages garnished because of the lawsuit. There is no mention of garnished wages in that case. So these are exaggerated, and I also want to point out that...
Wait just a minute, though. What about, because to me the most significant reason with respect to Juror Wright was the fact that she used to work for Archie Flowers Sr., had an employment relationship. Is that right?
Yes.
All right, well, I think you compare the white juror by saying there was white juror, there was a bank teller where the family did business. Do you not think there's a significant difference in terms of the desire to make a preemptory strike against someone who used to work for the father of the defendant as opposed to someone who worked in a bank where they did business? Don't you see? I'm not sure. My point is, I'm not sure that is a fair balance between the white and the black juror, saying you didn't strike a white juror for a reason, you struck a black juror. I see those as 2 very different.
And Your Honor, I actually am not disputing that those are not identical. I think if there is no perfect one-to-one correspondence between any juror, but the Supreme Court in Miller-El never said that that's required. It is a factor, and it is the strongest evidence. So there's different treatment. There's also different treatment with respect to the questioning to elicit the closeness of those relationships. All of that is not by itself sufficient, but when taken together demonstrates racial discrimination.
But don't you think, notwithstanding whether her wages were ever garnished being sued by Tardy, is that not a distinction that would be different from the comparison White that you had?
So I want to say two things about that, if I may. One thing I'd like to say is the fact that the evidence is mischaracterized is itself evidence of racial discrimination. The court said so in Millerette. So whether or not it's a different reason doesn't mean it's not that mischaracterization is not probative. It is. But the second thing I'm just going to say, Your Honor, is maybe...
How would you know that the prosecution didn't consult with the family about people on the jury? Like the Tardy family. What if someone told the prosecutor her wages were garnished? Do you have to ask her? Does that have to be in the record that he asked her and bring that out?
Well, the defense actually asked the court to review the record and asked specifically whether or not wages were garnished, and the court did not reply. So I think, is it possible there would be some other basis? The state could have stated a basis.
I mean, most good lawyers have a pretty good idea who's on a jury and made a lot of decisions before they ever walk in the courtroom.
That's certainly true. And in an ordinary case without any reason to suspect discrimination, one might give the prosecutor the benefit of the doubt on not having exaggerated just because he's an advocate. But here, the exaggerations all run in the same direction, and exaggeration is a mischaracterization. But I wanted to say something else about the second reason with respect to the victim. You know, if this had been a single...
Let me stop for just a second. Now, is there any judge in the world that wouldn't excuse a juror that had been sued by a party? By itself, nothing else?
For cause?
Yes.
By a party?
Yes.
By a party, yes.
Yeah, in the lawsuit.
It's not a party.
Yeah. Well, we have a victim that's a party. I mean, the family of the victim.
They're not well, unless it's different in Mississippi, I don't understand them to be a party.
Well, it's not a party, but this is the victim. The Tardy was the owner of the store. Employees of the store were murdered. They're the victims in this case, correct?
That's correct.
And then he was, it's undisputed she was sued by the Tardys. This witness was, is that correct?
That is correct.
You don't think that by itself is a reason that the prosecution was justified in seeking her to stand aside because of her possible misgivings or misfeelings about the Tardy family from that incident?
Your Honor, I think it is implausible that a person faced with a quadruple homicide, only one of which involves someone they had been sued by, would take it out on all of the other victims and the state by being biased about that evidence. I do find that implausible. But as I said, I don't think, that's why I said I don't think any of those reasons are not race neutral. I don't think they have a perfect match.
Would Batson require them to be implausible?
Pardon me?
Is Batson objection?
It
require?
does not.
It does not, does it?
No, but it requires that the totality of the circumstances be considered in evaluating whether or not racial discrimination has taken place. And indeed, that's the argument that I've made here, that when you look at the entire course of the history and the behavior in this case, the disparate questioning, the mischaracterization of the record, that the defendant met his burden here in finding that there was racial discrimination.
Ms. Johnson, would you clarify for me the working relationship between Wright and Flowers Farm? I thought I understood Justice Dickinson to say that she worked for Flowers Farm. Did she work for him, or did she work at the same facility?
I think she worked at the same facility at a Walmart, I believe,
Now,
which he didn't own.
now, is there any evidence in the record that speaks to the closeness of the working relationship there?
She says she's not close to it. But there's no detail about that elicited that would suggest closeness. I think that's a fairer description of it.
What was racial makeup? Remind me, I read it somewhere in the briefs, but for this purpose of this discussion, remind us of what the racial makeup was of the entire venire and the jury selected.
The venire was 28% African American, and the jury, as ultimately chosen, was one black juror, 8%. And that, of course, is a factor too, although of course, statistics don't by themselves prove racial motivation.
Does that include the alternates?
There was a black alternate as well.
Two alternates, three alternates?
I believe there were 3 and one was black.
But the trial judge required the state to go forward with race-neutral reasons, correct?
Yes.
So that portion of the Batson analysis, we're past that to whether or not the race-neutral reasons are appropriate.
Well, I know that the state disagrees with that, and if I understand Mississippi procedure correctly, the state can offer a reason not given by the trial court that would support the same determination. So if a prima facie case was not established, then that's an adequate reason for sustaining the decision in this case as well. Thank you. Oh, did you want to ask?
Other questions? Okay.
I have some, did you get the affidavit?
Are we talking about the affidavit with regard to lineup procedures? Is that the part you're interested in? Or would you
This
like to hear
affidavit
from
you
my counsel?
submitted that was signed by Dr. Scott Newshutz. He was,
Yes, that's in front of me.
that's what you have, okay. I was looking at the judge's reasons for not allowing him to testify. I'm sure you remember the judge indicated that pertaining to whether there are viable scientific principles upon which the research the good doctor was based, he indicated that he could not determine that there was a known rate of error pertaining to any of the independent variables as it relates to witness identification. Do you remember that?
Yes, I do, and in fact, I'm actually acquainted with that literature, and that's a correct statement of the literature. It's impossible to have a known rate that really is reliable because, of course, the rates occur from mock jury or mock identification situations, which are radically different than real-life situations. So
the defense attorney submitted the affidavit knowing that he was going to be rejected as a witness?
No, I don't think that's true, Your Honor. I don't think you have to have a known rate of error in order to believe that it is useful for the jury to know that the following factors make an identification less likely to be reliable. I think that is probative evidence that is useful to a jury.
And how would it be probative evidence if Daubert requires, in order for the research to be offered and the expert allowed to testify as to his research, there be a rate of error established?
Well, I don't think that Daubert requires that every piece it has a number attached to it. I think that would be, I think there's much evidence that's admitted that does not meet that requirement. I think should he have been able to say which caused the greater levels? I think that would be useful, but I don't think that it's a requirement of Daubert or this court's jurisprudence that there be a specific rate attached to any factor that is deemed likely to increase or decrease. I think it's also the case that actually the thing that's most likely to affect identifications, or there's the most evidence on, was not present in this case, and he doesn't discuss that, and that's appropriate.
So if you had been the trial judge, you believe it would have been within your discretion to have admitted Dr. Newshutz, but Judge Loper, in his discretion, determined that he would not admit the good doctor because he failed the Daubert test.
I think it would have been within my discretion to admit that evidence. I don't think that the converse is necessarily true, but I also think that part of the answer to whether the converse is true has to be examined by looking at how weak the evidence was in this case and the potential for juror confusion. And I'm going to say, although this is not a doctrinal piece, I'm going to say it anyway, the judge was very lenient with respect to the state's admission of gunshot residue, one single particle. I do think a judge has an obligation to be even-handed in his application of a general rule.
And the judge is bound by the law. Would you agree with that?
Certainly.
And as I read Daughtry, if the research is not capable of yielding a rate of error, then it's not research, it's speculation.
I don't read Daughtry that way.
You don't agree with that. Let's look at specifically the information provided in the affidavit. Did you close yours?
I did, but it's right back there.
Pertaining to cross-race identification. And in his affidavit, on page 6 at the top, in the second sentence, it states that Mesner and Brigham analyzed the results of 31 separate studies involving 91 separate experimental tests of own versus same race identifications. Now, what does that mean exactly?
Well, that means that in experimental conditions, which of course we don't have.
I know the meaning of the word experimental. Actually, what I was referring to was own versus same race. What does the good doctor mean by that phrase?
Well, as I understand the literature, it's almost all black-white identification, so there really is much less literature on white Asian or Native American white, but that when we look at whites identifying blacks, there are these substantially greater rates of misidentification.
Now, you're getting...
Not every case, of course.
You're getting quite a ways away from that phrase, though. In your mind, tell me, what is the meaning of own, O-W-N, versus same race?
Your Honor, I'm not sure. I
And
hate to be
I
stupid,
don't
I'm
think
not
the
really
trial judge was sure. And I am not sure. When I read that sentence, own, that's my own, versus same, I am the same, race identification. So to use a phrase you have used in this argument some, I believe that's a misstatement.
Well, I might be reading the wrong sentence. I'm reading across all studies, eyewitnesses were 1.4 times more likely to correctly identify members of their own race than members of other races.
Right, you're reading sentence 4. So sentence 4 contradicts sentence 3. We still haven't arrived at a rate of error. And if you go down to the middle of that paragraph, see the sentence where it says to understand cognitive mechanisms. Do you see that, Ms. Johnson? To understand the cognitive mechanisms behind the ORB effect, researchers have utilized Gibson's perceptual learning hypothesis. Tell me, what's the meaning of the word hypothesis to you?
A theory of why something might be in science.
Wait now, speak into the microphone. I have real trouble hearing you, so speak a little slower. I hear at a very slow rate, and speak louder if you will.
And I do talk at a fast rate, for which I apologize. having just spoken quickly, I'll try. A hypothesis in science, as I understand it, not being a scientist, is a theory or working idea of what might cause something else, something that is true in the world.
Something that might cause something else. Now, I know a little about statistics, and I would agree with that portion of your statement. I would not agree with the portion that you indicated stating it's a theory. A hypothesis is not a theory. A hypothesis is a statement of something that might cause something else. So we've still not arrived at any rate of error pertaining to cross-race identification, have we?
Your Honor, I don't think that's quite correct. I think the hypothesis is about Gibson's perceptual learning, but that's not the same thing as whether there exists in the world a greater rate of misidentification when the identification is cross-racial. And so I think there is data on whether there's a greater rate. There is not a demonstration of why that occurs.
May I ask you a question about that?
Yes.
That issue? This error
I
rate,
had one other question.
I'll just, so I don't lose my train of thought.
Oh.
This error rate that Justice Chandler's asking you about, was that an issue? Did anyone raise it? Did the state raise it, or did the trial judge ever discuss the error rate?
No, Your Honor. The trial judge did not discuss that at all in rejecting the evidence, and in a way this is an interesting conversation because this isn't a cross-racial identification. So this aspect of his comment, which I think he's just being thorough about, doesn't...
No, you don't need to get into all that for my purposes. I just wanted to know whether or not the issue of error rate came up during the Daubert hearing, either because the state raised it to question the error rate, or because the judge said part of my reason for rejection of this expert is there's no evidence of error rate. I want to know if you recall in the testimony, in the discussion at the Daubert hearing, whether that issue ever came up.
No,
And
Your Honor,
you can just say yes, no, or I don't know, and you're done with me and back to Justice Chandler. That's all I wanted to know.
Okay, now here's Judge Loper's statement. The defense has not offered to this court this idea that the theories the defense would testify to or the area of expertise proffered are generally accepted. I do not know whether the testimony has a potential or known high rate of error. Mr. DeGray stated, Your Honor, just for clarity of the record, the report from Dr. Neuschutz that the court was referring to, of course, we disagree, but admit that all they have is affidavit. That's why I was asking you whether from the affidavit there's a way of determining a known rate of error. I've looked at the independent variables Dr. Neuschutz identified pertaining to exposure time, appearance change, disguise, unconscious transference, and cross-race identification. I cannot ascertain where any of those are based on sound scientific principles. That was the basis of my questions to you, and I have my answers. Thank you.
Other questions? Thank you, John. May I proceed?
May it please the court. My name is Melanie Thomas. I'm Special Assistant Attorney General for the state of Mississippi.
Can you put that microphone down so that you're...
Sorry.
You're going to have to slow down too.
I can do that. With me at council table is Doug Evans. He is the district attorney for the 5th District. We also have with us today Brad Smith from the Attorney General's office, and we have 2 legal interns with us this summer, Lane Bobo and Evans Henry. So we would like to welcome them as well. Starting off with the issue of prosecutorial error, Justice Lamar, you stole my opening line. The issue is whether the natural and probable effect of the improper argument is to create unjust prejudice against Mr. Flowers so as to result in a decision that is influenced by that prejudice. And that standard, yes, sir.
Let me ask you the same question I asked Ms. Johnson as she was starting. Given the fact that this case has been previously reversed, find an error in 2 of the issues that were raised today, that being the mischaracterization of the evidence by the state and the Batson issue. What weight should this court give to that?
Your Honor, as a representative of the state, I'm going to say that if we did it differently, then you give no weight. Because what we are doing as the state of Mississippi is taking into account this court's admonishments. And if we make changes that this court deems token changes, then you're right. We have done this court a disservice. But if this court deems that our changes were not token changes, and the state submits that they were not, then we get a clean slate. We get to start.
What changes did the court, did the state make on those 2 issues?
Okay. With respect to Sam Jones, the testimony that they tried to say that we mimicked was testimony from 2003. And what happened in 2003, this is where Flowers 2 came in. This is the testimony that this court found objectionable and told us to change.
Remind me now, Sam Jones, the one who had died before this trial?
Yes, ma'am, that is
So we're
correct.
talking about a reading of testimony in this trial from which previous trial?
This is from the
2004?
Yes, from Flowers 2. So let's see, the first trial was, I think it's 2000 and...
First case was reversed in 2000. Then that involved 1 victim.
Yes, that's
Then there was a
correct.
second trial, which I've been calling Flowers 2, which was also a trial that involved 1 victim. Is that correct?
That is correct, yes.
And then the Flowers, which would have been the 3rd trial in 2004, was the first trial that was a trial that involved all 4 victims, correct?
Yes, that's correct. Flowers 3 was the trial that dealt specifically with Batson. Flowers 2 was the trial where we had 14 instances of alleged prosecutorial misconduct.
So my question was, the testimony that was read in this case from Sam Jones?
The testimony that was read in this case was from 2007, from Flowers' 5th trial. This is where it gets confusing.
5th trial.
Yes, that's correct. But the testimony, they say that we attempted to mischaracterize, where we were not following this court's admonishment, was from 2003. And here's what happened in 2003. The state asked Sam Jones, there was a question about when he arrived at the store. So we're in the general vicinity of what this testimony is. And during closing argument, the state said, Jones has testified he got a call from Bertha at 9:30. At this point, the judge actually admonished the jury and said, don't forget, we are talking that the arguments of prosecutors and the arguments of attorneys are just arguments. And at that point, the state actually...
Why would the court have interjected at that point?
That's the finding from Flowers 2. But at that point, the state actually rebutted that and said, no, Jones said he received a call around 9:30. I wrote it down.
Ms. Thomas.
Yes, sir.
I don't want you to get too sidetracked from what my question to you was, because you've not responded to it.
And I apologize, Your Honor. What I want to say is that the admonishment from 2003, because there was no objection in 2007 to any comment that the state made during closing argument. In fact, what's in closing argument is not even there. So
my question to you is, what did the state do differently? That was what you told me.
First,
the state acted differently as regards each of those issues. So if you would, without the editorializing, Please tell me what it is that the state did differently.
First of all, we never argued that Jones testified he arrived at 10 o'clock. I think that's a big key. Second of all, what we said was Jones arrived at 10. That's what we said. And we do submit that this was a reasonable inference based on the testimony given. According to Jones's testimony, he received a call from Bertha Tardy, he drove to Tardy, and he arrived at Tardy all at the exact same time, 9:15. Then he stayed there between 10 to 15 minutes, a statement that even defense counsel characterized, you probably didn't stay there that full amount of time. And then he hurriedly walked 3 doors down to call 911 at 10:20. There's an approximately 40-minute gap in his testimony. And in Anderson versus State and in Rule 611C, we can use direct examination to clarify a witness's testimony, especially if it appears contradictory. We would submit that Sam Jones's testimony does appear contradictory. I think it's fairly difficult to get a call from someone, drive to a store, and enter a store all at the exact same time. The other thing is that we didn't say, hey, he did say that, I wrote it down. The irony, of course, is that defense counsel did. And during their closing argument, it was defense counsel who capitalized on the statement by saying, I wrote it down. His testimony was that he might have gotten there as early as 9 o'clock, which is actually factually inaccurate and comments directly on the testimony, something that we did not do. So if you were talking about mischaracterizations from 2003, we never said Jones testified. Now, does that become a technical issue? Jones testified versus Jones came. We were talking about a statement versus an action. The submission that the state makes is it becomes less of a problem because we are tying that action to the facts and circumstances and the inferences and deductions of the rest of the evidence, including a 911 call. Also, we made no direct comment on what Jones said. So we are following the admonishment of this court from Flowers 2. We would submit that there is no error there, that we did not mischaracterize, that we did not commit
In your
passive.
statement to the jury,
Yes, sir.
did you say, hey, 1, 2, 3, 4, as a result of these things, we conclude that this is the time that he arrived?
No, sir. Actually, what we did was we talked about the way that the district attorney sort of characterized this was, let's look at all the different pieces of the case. What we were trying to say was we had 3 witnesses who placed flowers at or around Tardy at or around a certain period of time. We had 3 witnesses who placed flowers at or near the scene of the gun at a certain period of time. And we were working that to show where Flowers' moves were. And that comment about when Sam Jones got there, when Charles Collins saw it happen, when Clemmy Fleming made her eyewitness identification, when the 911 call came in, those were all reasonable comments on the light of the evidence, in the light of the evidence.
Your position, when in closing, during the timeline discussion, quote, Mr. Sam Jones came into the store slightly after 10 on the morning of the 16th and discovered the bodies. From whence did that timeline, that slightly after 10, it's not from Sam Jones' testimony?
It is an unanswered question from Sam Jones' testimony. The question that was issued to Jones, and you'll remember that it was read into the record because he had passed away at this time. The question was, Jones testified initially that he arrived at 9:15. The state, from 2007, asked Jones if it was more like 10. Again, pursuant to 611, we are clarifying testimony based on what Sam Jones had testified, how he had gotten there. The defense did object to that question, and the judge overruled, and Sam Jones never answered the question. So that's where we are. We were left open-ended on the question. So admittedly, he never said he was, he never said he wasn't. His statements, taken in context, we made a reasonable inference from that. The other thing that we have to look at, too, is, we're talking about latitude and unjust prejudice here, and they attempt to sort of tie these other factors to it. The beef with the store, the location of the victims, the identification by Charles Collins. Actually, we would note that in terms of a beef with the store, the family had told the police that they considered Flowers a threat. that they were concerned about their safety.
Is that in evidence?
That is in evidence, yes, Your Honor.
But
Flowers,
that's the family's perception. Point me to the evidence in the record that speaks to the attitude exhibited by Flowers.
well, again, I think you can make inferences from the fact that he broke batteries, owed Bertha Tardy $30, was fired from the store, and the family considered him a threat. I think that's evidence.
My question to you is the evidence in the record that speaks not to the family's perception of him, but as to his attitude.
Again, we're talking about a man who was fired after he broke some batteries and had his paycheck docked. And if you're talking about inferring intent or inferring motive, based on that, you can look at cases like Howell versus State. You can look at cases like Duplantis versus State. In Duplantis, a capital murder case, they inferred robbery from the fact that he was a prison escapee and needed money. He didn't have any money. Flowers had been fired from the store. He admitted he only had gotten $119, and that was 6 days earlier. He knew he still owed Bertha Tardy money. He knew he wasn't going to have a job. Moreover, I don't think that you can be allowed to parse that issue and say simply because Flowers never testified he had a motive, that there was no motive. I think that makes it an impossibility. You also have Doyle Simpson, who, while not allowed to elaborate,
did go to whether or not Flowers testified as to his attitude. The question is, what evidence is there of his attitude, as opposed to the perception of other people as to what his attitude is?
Again, what I can say is that...
Is there any evidence in the record that goes directly to what his attitude is, other than the perception of other people?
Yes, Your Honor, there is. I mean,
and
again...
what is that evidence, since you said yes?
He's been fired. He's had his paycheck docked. He owes Miss Tardy money.
Those things speak to attitude?
I think they do.
How so?
I think that you have disgruntled postal employees all over the country that can
But he's not a
attest.
postal employee, so I would assume that we're not worried about him going postal on somebody.
I don't know why we wouldn't be. I mean, that's, we're in a capital murder case. The jury doesn't have to have intent to kill. We can talk about he had a beef with the store without saying that he had an intent to kill them. We can say that he was angry.
The proof of the beef is the question.
Your Honor, I feel like I have given you the proof that is there, that the state believes that is there. We would also submit that Doyle Simpson also testified in a very limited capacity that he knew Flowers had problems with the store. He was not allowed to elaborate on that, but he did testify that Flowers had problems with the store.
Before you get away from these alleged misstatements, can you clear something up for me?
Yes, sir.
Going back to Mr. Jones, as I understand the defendant's issue in this case, it is a misstatement of the arrival time.
Yes, Your Honor.
Is that the issue?
That we lied about Sam Jones's testifying he arrived at 10.
All right. I did not understand that to be the same issue in the prior case. I thought the issue in the prior case was not the arrival time, but the time of the telephone call.
That is correct, Your Honor. The question at that point was, did he receive a call from Bertha Tardy at 9:30, or did he arrive at Tardy at 9:30? I think that...
My point is, that I'm trying to understand, is whether or not the prosecution had any, it sounded, the tenor of the argument here today sounds like the prosecutor should have known better because the court admonished you on a prior occasion. I don't see where the court did that. It looked to me like the court admonished the prosecution for misstating about the telephone call.
And again, that goes back to, we would submit...
Is that right?
Yes, sir. That's our understanding.
Well, stay with me a second, I'm slow. So the state, this court, in the previous case, admonished the prosecutor about misstating the facts concerning the telephone call. Did this court make any admonishment or criticize the prosecutor in any way about any discussion and closing argument concerning the arrival time? Now, I know that, I'm sorry, I didn't mean to interrupt you, but I know that the court mentioned, in the opinion, I know the court mentioned what Jones testified to. He testified he arrived at a certain time, but the court, as far as I could read, the court never criticized the prosecutor for any statement the prosecutor made about the arrival time. Is that right?
My understanding is that is correct. The court also in Flowers 2 found cumulative error. There were 14 instances. So the court also specifically did not find reversible error on that one particular issue. They noted that it was cumulative error and that most of the comments by the state with which it took issue was apparently where they had been.
There wouldn't be any issue of cumulative error if this wasn't an error.
We would submit it's not an error at all, exactly.
Okay, so
I'm
just trying to decide whether or not there has been an issue of misconduct related to Jones' arrival time.
We would not submit that there has.
Okay, so today, in this trial, the state's position is the prosecutor, in closing argument, makes a statement of what time Jones arrived, and the prosecutor's statement to the jury is different from what Jones testified to in terms of, I got there at 10:20.
He said he arrived at 9:15.
I mean, 9:20?
9:15.
9:15. So Jones testified to a time, but clearly, as Justice Lamar pointed out, if you look at the 911 call, which is in evidence at the time of the call,
Yes, sir.
how do we know what time the 911 call took place?
I think it's written down on the transcript.
All right. So we have evidence of the time of the 911 call, and we have Jones' testimony that he got there 20 minutes before?
He said that he got there an hour and 5 minutes before the 911 call and was there for only 10 minutes before he called 911.
All right, so for the state to conclude from those two pieces of evidence that got there at 9 o'clock, and not having been admonished or having that issue raised at any time in a prior case, your position then is it's not that it's harm, there's simply no error here.
We would submit that there is no error whatsoever.
Okay.
The two big questions that you have to ask here is, did the state err in asking Jones if he arrived at tardy at 10 instead of 9:15? That's the first question, and the answer to that is no. Pursuant to Anderson versus State, pursuant to Rule 611C, you can lead on direct where you are attempting to clarify testimony which might appear to be contradictory. Anderson dealt with a young victim and the dates of the indictment. Mr. Jones was 87 at the time, so we sort of are on the opposite end of the spectrum. The state submits that we did not err in asking him whether his arrival was actually different based on those inconsistencies. The second question is, did the state err in stating during closing that he arrived at 10? And as we have submitted, we do not believe that that was error. We believe that that was a reasonable comment on the evidence. We didn't harp on it. We didn't say he testified to it. We didn't tell the jury I wrote it down. We said he arrived, and we moved on, and we talked about the evidence that showed his arrival matched up with that 10 o'clock.
Okay, I'm sorry for diverting your attention. I just wanted to be clear about what the issue was in the prior case.
Yes, sir.
Okay.
Yes, sir. Okay, with respect to the location of the bodies, again, what the prosecutor said was the bottoms of all 4 victims are laying in a pile in a group right at the front counter. Mr. Flowers is correct. Bertha Tardy was not at the front counter. She was in the aisle that led to from the front of the store to the back of the store. The other 3 victims were all at the front counter. It was sort of like a cash register counter to sort of give you the dimensions of that. There were pictures of those bodies introduced into evidence to show their positioning to where they laid. We would submit, obviously, that the word pile and the word group and the phrase at the front counter is proper phraseology. The other thing that we would submit is this argument about a single assailant versus a double assailant. That was neither theory at trial. That the single assailant theory that Flowers could have been able to do it was not our theory at trial. Our theory at trial was that Flowers did do it because he had all of these problems with Tardy. They also did not argue a double assailant theory. They did not argue that it was impossible or unlikely for Flowers to have been able to, by himself, kill 4 people.
And we don't know whether all of the people were shot with the same gun.
We do. They were all killed by the same weapon.
If they were all killed by the same weapon, what difference does it make if there was more than one perpetrator?
Well, I mean, I certainly think that that's a question that the jury might ask. But it's not an issue that we were not trying to focus on. Was there more than one person? Was there, was there a double assailant issue? Could Flowers have been able to single-handedly commit this robbery? The police focused on Flowers. They looked at the evidence that pointed to him, and that's how the state proceeded with that case.
I'm just trying to understand, as I asked earlier, I'm not sure why it matters where the bodies were found. You got one gun, unless they passed the gun around or something.
It didn't matter for the purposes of the state's case.
If it's not debatable that somebody walked in that store with a gun and killed all those people, that's not debatable. I don't think the defense denies that. Somebody did it with the same gun. If that's so, what difference does it make when the bodies were found?
Well, and I don't think that it does make a difference. And I think that that's why the state used the phrase in an argument and then immediately moved on. They said, he walked in, he found these bodies lying at the front counter, and then the very next statement that the state made was, now we're going to talk about connections. Let's talk about how we get Flowers to this case. So the state isn't harping on it. They aren't focusing on the location. They make a statement and they move on.
Ms. Johnson, I hope you'll answer. I don't mean to be asking her a question. I should be asking you, but I'm still perplexed as to why this matters, and I hope you'll address it in your rebuttal.
Are you telling us that the crime lab positively established that the same weapon fired all of the bullets that were recovered from the bodies?
To the best of my knowledge, to the best of my knowledge, a .380 was the gun that killed all of the victims, and that was the .380 that was stolen.
The bullets were mutilated, as I recall, Dr. Haynes' testimony.
Some of them were, but then the ballistics analysis came back, and the evidence that they had tied that .380 to those 4 victims.
They did not recover the weapon itself, did they?
No, I cannot remember, Your Honor. To be honest with you, I do not think that they did. Finally, we have the Charles Collins and his eyewitness ID. We have 2 lineups here. We did 2 6-pack lineups. And what the state said was, Porky did not misidentify anybody. He said the guy ain't in there. They took another 6 photographs and said, look at this second set. He said, that's him right there. He made a positive identification. That is correct. That is accurate. There were 2 eyewitness, there were 2 6-pack lineups. In the second lineup was Curtis Flowers, and the first lineup was Joel Simpson. I want to do this in reverse, because the second lineup with Flowers, Porky Collins has said, I will always believe it's that man right there. With respect to the pretrial lineup, he said, I think that's him, I believe that's him, I'm sure that's him. And then he testified at trial, the man I picked out of the lineup, Curtis Flowers, was the man I saw in front of Tardy Furniture. The state also presented evidence from Wayne Miller, who was present at both lineups, and he testified that Charles Collins positively identified Curtis Flowers from the second lineup. So then we go back to the first lineup, okay? If Charles Collins positively identified the only person he admitted to seeing, and admitted to actually viewing. He saw 2 people, but he couldn't see the second person. If he positively identified Flowers from the second lineup, he didn't identify anybody from the first lineup. You can only pick one. There's not more than one person Charles Collins saw. So going back to the first lineup, what did Charles Collins say? There was a suppression hearing in 1999, and the way that the hearing started was that defense counsel, actually Mayor Lumumba, was reading into the record notes from that police lineup about what Collins had said about the first lineup, about the Joel Simpson lineup. And what Collins said, according to the police notes, not Collins' own testimony, what he said, according to the police notes, was that 3 people in the first lineup, in the Joel Simpson lineup, looked similar or resembled the perpetrator. One of those people was Joel Simpson. And then Collins said, that resembles the person, but. That resembles the person, but the hairline is different. And he said, of those 3 men, their complexion is similar, but the hairline looks different. So when we're talking about Collins didn't pick anybody from the first lineup, he didn't pick anybody from the first lineup. The word but makes this a very understandable situation. We have witnesses regularly who say, yes, this looks similar, yes, this person kind of resembles it, but he didn't pick anybody. He picked Curtis Flowers. And from that, the state went on and asked Collins again during the suppression hearing about what his memory was of the lineup. And Collins said he does not remember picking out Simpson. He couldn't answer the question. He didn't remember. So what we have here is the state commenting on evidence of Collins picked out Flowers. He didn't pick out Joel Simpson. And when asked later to try to refresh his memory, even when they tried to get him to say, oh yes, I picked out Joel Simpson, but I changed my mind, he didn't do it. He said yes, but. And we would submit that that word makes this a proper comment on the evidence.
At this time, it's about 3 o'clock. We're going to take a short recess, 20-minute recess, and we'll resume as we were at 3:20.
Thank you, Your Honor.
At this time, the court will stand in recess.